The fourth case on this morning's docket. It's case number 104533, State of Kansas v. Murdoch.
May it please the Court, the State appears by Assistant Solicitor General Natalie Chalmers and requests 3 minutes for rebuttal.
3 minutes is granted.
The State in this case is essentially asking this Court to modify its decision in order to close the prison gates that this decision appears to have opened. It is the State's opinion that there are 3 different ways this Court can either completely close the prison gates.
Is that the way we do it? We get the result we want and then work backwards?
No. But in this case, this was done for 20 some odd years, 23, I think, maybe 24 now. The legislator never stepped in and told anyone to do it differently. Just the legislative intent here, pre-grid and post-grid, was always to look at the criminal history score, look at the criminal history actions of the defendant, and determine the appropriate severity level and the appropriate sentence. What this court, the majority of this court did in Murdoch, was essentially strip the sentencing guidelines of its value by saying convictions such as murder, rape, in this case robbery, are no longer going to be treated as seriously pre-1993 as they would be treated post-1993. How
do you say that? Pre-1993, they weren't person felonies. We're just treating them like they were defined before 93.
Before 1993, they had the indeterminate grid sentence. They could look and say, you've been convicted of murder again. I'm going to give you a longer sentence in this indeterminate sentence. Now you're stripping the courts of their ability to do that by freezing it and saying you can't consider anything but non-person, despite the fact that this is a rape, despite the fact that when it first became a grid in 1993, rape was defined as murder. I'm sorry, rape was a person felony, murder was a person felony, robbery was a person felony. It's been a person felony since 1993 on.
Whether it was labeled that or not, that's your point.
Right.
I have another question. Mm-hmm. Was the Williams case correctly decided?
I think the Williams case can be distinguished, but no, I don't believe it necessarily was correctly decided.
The state should have had a different outcome there.
Yes. I think a more easy to apply rule is to look at just what this court has said for years. You look at the crime as of the date the crime occurred. In this case, it was 2008.
What about the wording of the statute?
I want
to talk about the wording of the statute a little bit.
Okay.
KSA 2147-11E. Mm-hmm. It's written in the present tense as to what Kansas has, rather than had.
Sure.
Does that make a difference?
I think that goes along with, the rule is that you have to look, you can't impose a more severe criminal history or sentence. We can't heighten it due to ex post facto violations. So it would be at the time the crime was committed, you find the comparable. So here in 2008,
Williams was correct. I thought you just said Williams was incorrectly decided.
No, Williams froze it back in 1992.
Okay.
I'm just talking about the present conviction.
Okay.
Everything would start in 2008. You would take the 2008, you would look at the way the legislator does criminal history in 2008, and in 2008, robbery actually had not fundamentally changed.
Okay, I misunderstood what you were saying when you started your answer.
Yeah, and that's my first option for the court is essentially follow the plain language of the statute.
When the new crime was committed. That's what has references.
Yes.
Okay.
Sorry. And that's the first option. I think that option goes along with the dissent. It goes along with the way the district courts and the sentencing, I don't know what the people who do the PSIs are called, but whoever that does the PSIs have regularly done this for the last 20 some odd years. They have looked at the comparable crimes as of the date of the current offense.
So, just to clarify, you're asking us to reconsider and reverse our decision in Murdoch based on reversing our decision in Williams?
I don't know that you necessarily have to reverse in Williams, but I'm perfectly willing to allow that to occur. Williams is distinguishable because Williams involves the grid sentence, classifications. They didn't exist in 1993, I can't dispute that. But Williams involved what do you do when the legislator has changed the person versus non-person, not when the person versus non-person never existed. So if you want to limit Williams to the grid sentences and everything that happened after that, that's, as the dissent suggested, that's one way to do it. Or if you want to find an easier rule.
And how is that intellectually honest to do that? I mean, I can see how you could say, yeah, this car is green instead of that car is red, but how do you make that distinction intellectually?
And I think if the distinction can't be made, by all means, overrule Williams. But I think the distinction is 1993, when they said how you classify crimes, they did it differently. They did it with severity levels, and they did it with person versus non-person, either felonies or misdemeanors. Pre-1993, the classification was, I believe, A through E, and then there was some unclassified. The sentencing grid, when it talks about classification, is talking about the way you classify after 1993. Williams is an after 1993 classification of a grid sentence.
So do we have unclassified felonies now?
Yes. I believe so. I believe the Chapter 8 is full of them. I'm not sure what else. I don't deal with them very often, but I do know they do exist. And actually, so first option, freeze in this case 2008, but the new crime, use the new crime. The second option is look at
and that's just a statutory interpretation argument.
Yes, a statutory interpretation.
And
the next
means
one,
Williams is wrong.
Yes.
Okay.
Or at least can be limited, but Williams is wrong is also fine. The next one is to look at Chapter 34, prior to 1993 and post-1993, designated person or crimes against persons. That was the label, and I understand that that is not something the legislator necessarily gives. But pre and post-1993, if you look at all the crimes that were switched and actually given designations, most all of them in crimes against persons that then entered the grid became person designations. And certainly robbery did, rape did, murder did. It's a few others that I don't regularly see as crimes anymore that didn't make it. So another option is just to freeze as of 1993. Say that was what the legislator intended. It's the first time they bothered to define person versus non-person. It uses the conversion statute. But the designation based on Chapter 34 is actually more limited than if you just freeze in 1993, because freezing in 1993, which is the third option.
Explain that again, freeze in 1993. Go ahead, explain
Okay,
it
sorry.
again. Sorry.
So in 1993 is when the legislator first
Right, that's when we adopted.
Right, non-person versus person. So to look at what the court or the legislator would intend to be a person versus non-person felony, you can look at July 1st, 1993, and use those crimes. And those crimes.
I see what you're saying. Okay.
Yes. And in my brief, I think I argued that the out-of-state would be different, and I made that argument. I'm sorry, not my brief, my motion. Our motion. The out-of-state would be different. But that actually, if you just freeze it 1993, it would be broader because the sex crimes were also a person. But pre-1993, if you use the designation that the revisor's office gave, the sex crimes wouldn't be included because they weren't in Chapter 34. And then, so I think any of these options are reasonable. I think the first option is easiest and the most reasonable and most follows the legislative intent and language. But regardless, I think that it would be, we're just asking you to follow the legislator's intent, and I think it's unreasonable that the legislator intended, based on 1993, even though it came up with the entire new system, that suddenly murder doesn't count anymore. It not as severe, and it shouldn't be classified in the classification as more severe.
Why? That's the one thing I've been struggling with is why is it unreasonable in terms of legislative intent? I mean, it's because those guys don't like criminals. I'm not sure I understand that argument, and the reason why I'm confused is I look around at some other criminal statutes. Look back on DUI is the one that popped up to me a couple weeks ago. when I was thinking about that. Legislature changed that and said, beyond a certain point, you don't look back. And I didn't think the legislature liked drunk drivers. So it just seems to me, you look at the language and you go from there,
But here you have to look at
rather
like,
than trying to put a legislative intent behind it when we don't have anything to look at for legislative intent.
but here you have an entire classification system which stresses the fact that it wants to be fair and reasonable. It talks about person and the fact that you want to, I mean, the purpose of the classification, the very classification it wanted in 1993 was to look at the severity level of crimes, the person versus non-person. It just makes no sense that they would say, oh, well, we didn't really care if you committed a murder in pre-1993. It doesn't make sense to me with the overall purpose of the entire reason the grid sentences came into effect.
Why not just say it?
Because our legislator is not perfect. That is the best answer I have for that. It would be absolutely best if they had said it. But I think that they thought they were saying it. And since 1994, we've been doing it that way. Regardless of the fact they haven't said it.
How would they have thought they said it from the statutory language?
If not from the statutory language, from this court's, or the Court of Appeals, at least, interpretations of the statute since 1994, they have not changed the fact that we have been treating these as person felonies.
But they didn't change anything after Williams was decided.
I don't think, the state certainly didn't foresee how big of an impact Williams would have. I don't
Well,
think
you
that-
asked us to do what we did in Williams.
We did.
Now you don't want us to do that anymore.
We have more facts available to us now. We're not, as Justice
Now
Butler
it's gone
said.
the wrong way.
Yeah, we're
I
not
mean, that's the new
clairvoyant.
fact. Now it's gone the wrong way.
Right. We have new facts.
You
We-
could have read the statute the same back in Williams. I mean, that's why I got to Williams right away.
Yeah.
I just think that in order to be intellectually honest, to use my colleague's phrase, Williams has to be wrong in the way that we've discussed.
Okay.
But back then, the state was really happy to go that direction because the outcome was going to be good.
Right. They were outcome. No one saw that this was going to apply to pre-1993 classifications.
Be careful what you ask for.
Yes. I mean, we're not the only ones who get things wrong. We're not clairvoyant. We made a mistake when we asked for that rule, and
So
we now see the
What are the new
implications.
facts that are at hand now besides the fact that it's going to go the other way?
The fact that it's going to go over the way, not just this case, but in numerous other cases, this isn't limited anymore. We now know, because I've had to deal with numerous motions in front of district courts, I've been having county attorneys, I know this is on the record, we know that this will now have a broad impact. In Williams, limited impact. No one foresaw the fact that it could broadly implicate the way this court's decision, as it currently is written, will implicate criminal history and the defendants in this case. And I know,
Why is it up to us to rectify your misconception rather than the legislature? You could get relief from this by going to the legislature.
maybe. I can't see how we could get a statute that wouldn't have ex post facto challenges right and left. Equal protection based on an arbitrary date, etc. It's possible we can do that, but it's possible we can't. It's possible that had the court interpreted this back in 1994, sure, we probably could have done a legislative fix and just had a limited number of people affected. We don't know that today.
I do have one other question about your motion. As the author of the opinion, I can kind of see where you're coming from on the point about the application of it. Your 3 points sort of are a full win. I assume you're not, back because you haven't mentioned it, I assume you're not abandoning the notion that we clarify that this is an out-of-state, that this particular case
Right,
is out of
that was
state.
going to be my next
I mean,
request.
syllabus 4 says that plain out. Now, I realize there's a sentence at the end that doesn't have that, and then Justice Rosen confused it even more, but you haven't abandoned that
No.
bit of relief just because you didn't
No, and the
part of
other
your 3.
very limited relief that we would ask is that exactly, at least limit it to in-state, let us argue out-of-state based on the conversion statute. And also, if you would tell us whether or not this is a new substantive change in the law. We would very much like that answer.
And maybe I'll clarify this with Mr. Dunn, but this had nothing to do with conversion. I mean, the facts stood before us that it was an out-of-state conviction, but what no one contested that the aggravated robbery in Murdoch was accurately converted. It had to do with the pre-1993 status of
Right.
it not being person or non-person.
Right,
That's
right.
the
I'm
issue.
sorry. The conversion to me is
It wasn't ever, the conversion was never contested.
right. No, that to me is an argument as to how you get to the fact that the robbery should be a person felony is by using the conversion statute. Not that he's trying to argue that it should be an indeterminate versus determinate sentence. The state stands here today basically asking you to, if not close the prison gates again, partially close them.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Patrick Dunn, Deputy Appellate Defender here today on behalf of Jimmy Murdoch.
Mr. Dunn, if Williams was correct, and then us following Williams and Murdoch was correct, why does the statute talk about what Kansas has as a comparable rather than what it had?
You know, I'd point the court back to the oral argument in Williams. And I put that in my motion because I think it's so appropriate that the state now cares about tenses. When it was specifically raised in Williams, Ms. Barr was before the court, Justice Johnson was asking, and it's around 5:10, I believe, is when it starts in the during the argument, and Ms. Barr was saying, well, we should be using the current statute because at the time that was advantageous to her client because it's 4711E says we look at whether it is designated. The comparable Kansas felony is. She said, well, that is. We should be looking at what's current. And Justice Johnson said, no, we actually is refers to, I mean, we obviously know that the end result in Williams did not mean that present tense is just meant what it is at the time. Now, the state now, and Mr. Obermeyer was asked around 27, 28 minutes into the argument. And he said, well, it depends on what your definition of is. I presume making a former President Clinton joke there. But this was all talked about then, this tense matter. Really, the big difference now is the result. The state got the result it wanted in Williams. The Attorney General's office signed off on the brief. And frankly, the fact that this Attorney General's office wasn't thinking about it's kind of interesting to me because the cases they argue, Boster, Henderson, those are 2009 cases. Those are pre-Williams cases. So the Attorney General's office should have been aware that our office has been raising this issue even before Williams came down. Now, in that case, they got what they asked for. And I think it's, if anything, almost an estoppel type situation where they can't now say, well, wait a minute, we didn't fully think this through. But the court presented in Williams different options, and it gave a well-reasoned, frankly, response as to why it was choosing those. First, you have a lack of statutory guidance, and the court cited Washington and Florida, saying in these other guidelines states, and Washington was actually one of the states where Kansas modeled its guidelines after. But in Washington and Florida, where they don't have a statute, they say out-of-state crimes are scored at the time when the out-of-state crime was committed. In contrast, Minnesota, another state that Kansas modeled their sentencing guidelines after, actually has a statute that says, hey, we do this as of the date of the current crime. Court pointed this out and said, we don't have statutory authority, so we're going along a similar route as these other states. Ms. Williams presented this almost the same type of arguments of alternatives that the state's now presenting. Well, we can look at it at the time it was committed. We can look at it at the time of the current crime conviction, and now they're bringing up July 1st of 93, which presents a whole other realm of problems because, say in Williams, there wouldn't have been a crime of identity theft. That would have made that a non-person because there was no identity theft as a crime in July 1st of 1993. So I don't see where there's anything new since Williams other than a potential result. Now, speaking to the results, I think the state greatly over-exaggerates the implications of this. First of all, as I mentioned in my original oral argument in this case, I think, and frankly I don't want to make the state's potential future arguments for them, but I point out, if you look at KSA 214707, I want to say C2, it says off-grid crimes are treated as person felonies. Now, if you look back to 214706, it provides a list of what off-grid crimes are. And a big difference there, and this kind of dovetails burglary, which I want to talk about a little bit. It says, for instance, KSA 213401, 213429, which is capital murder, the terrorism statute, the mass destruction statute, and 213801, which is treason, and amendments thereto are off-grid crimes. So, using that and amendments thereto language, the state could hypothetically, in a future case, and again, I haven't mentioned this before, but the state's asking about all these future implications, and that's not the role of this court. This court does not provide advisory opinions because there's different facts and different situations and different arguments. We're looking today just at the out-of-state conviction of robbery. But it's by that language of and amendments thereto, arguably, it state, well, because we have that statutory language saying and amendments thereto, that evidences the legislature's intent to look at the current statute. We don't have that in 4711E for anything else. So the legislature specifically delineated in 4706C. Also in 4706D, it talks about, for just to be concise, basically Jessica's law cases now that are off-grid. So arguably, a lot of the cases that the state is saying we're going to open the prison gates on, there's a very good argument that that's not the case in any of those cases. Those are all still because 4707C2 says we treat those as person felonies, that we're not just opening the gates on these things. These are, and again, this is something that's not briefed by anyone because this is all after the fact, and it's not frankly relevant to this case before
Well, let's
the court.
get to something that is relevant. The statute says unclassified felonies are treated as non-person.
Yes.
And so the question becomes, does unclassified felony, is that a term of art, or do we apply common meaning to ordinary words?
Well, to be honest with you, I've argued I wasn't going to talk about that because I thought we were just talking about why we should be rehearing, but I'll go back to the exact same argument I made at the original argument. I think we use the plain language of the words. Doesn't have a special definition. Now, I acknowledge at the previous argument, Justice Rosen pointed out, well, back in the dark days of indeterminate sentences, that was something we considered a term of art that weren't A, B, C, D, or E felonies.
That's what they were. They were called unclassified felonies, and they still are called unclassified felonies. No one's making that up. That's what they're referred to. And that's a severity level. It doesn't have anything to do with designation of person or non-person.
This is part two of the same exact thing, and
Right.
I don't want to
Right.
rerun over that.
We
So I
disagree.
wasn't planning on.
I know we disagree, but
I frankly
that's
wasn't going to talk about it because the opinion even we acknowledged that even the opinion said I was wrong on that, and so frankly I wasn't going to talk about that today. But I still think I'm right. No offense. But I wasn't going to replow that same ground because I thought we spent plenty of time on that before.
Well, let me get to the point that I think I was trying to make in my dissent, and that is when you look at the entire sentencing structure and why there was a necessity to convert from a non-determinative to a determinative sentencing scheme. It was because of sentencing disparity. That was the main reason, and also a little bit to control prison population. But the main reason was there was demonstrated disparity in sentencing, both based on geographic location of crimes and racial determinations. That's a given. So great study went into this. Sentencing Commission came up with their recommendations. The legislature adopted the determinative sentencing that was completely based upon trying to make it a system that no longer looked at certain, took away discretion, quite frankly, and a lot of us trial judges were upset by that, but it did take away discretion, and focused on present crime, the nature of the present crime, and categorized it as a person, non-person, and the severity of prior crimes. And I'm not telling you anything you don't know, and set up the grid system. And I just don't see how this just doesn't totally undo that. The whole basis of categorizing prior crimes as person or non-person was a public safety concern, took away some of the discriminatory factors that can be had in sentencing, I suppose, or some of the discretionary factors, and said, this is what it's going to be, this is how it impacts it. And our entire sentencing scheme is based on that. And in my mind, by the Murdoch decision, just undoes that, completely undoes that, at least as it relates to prior to 1993 crimes. And that's my concern, and if that's not an absurd result, I don't know what is. And I guess that's if you can respond to that, go ahead. That's where I don't understand. I mean, that's kind of where we're at.
So your question
is, why is that not an absurd result when we have that kind of when we have that type of review? I mean, I'm loath to get to that point. As you know, I think all of us strive to put common sense into this, defer to the legislature as much as we possibly can in these cases. We've had several cases this week that ask that very question on plain language. But where is this? Why is this not a result that's completely not contemplated and kind of sets the sentencing scheme on its head?
Well, first of all, as I said, I think that I disagree with the foregone conclusion, and frankly, I think, with all due respect, Justice Biles, I think the language in the opinion saying that we recognize that this may make all pre-93 cases non-person, I think that was overreaching. First, as I mentioned before, burglary was addressed, and I know it's not appropriate with
that indicates the legislature knew how to do it, I suppose. But right, but go ahead.
Well, again, and this is fundamental with how we do statutory interpretation. But what I'm not disputing that the stated intent, in 1989, when they put together the Sentencing Commission, it took 4 years to finally come out with the guidelines. And we have these general principles. But then we get into what constitutes a violent crime. And clearly the legislature has
a person crime, and they were described as crimes that are typically defined as included in the elements, included as a person. I mean, that's typically how it's described, and almost all of the person crimes.
I may be wrong, but I believe that the overarching principles of the Sentencing Commission were violent offenders. It didn't say
Correct.
Person crimes.
Correct.
So I'm just saying.
But how they distinguished whether they were violent or not was by categorizing them as person versus non-person.
And I'm with you there. But my point being, though, what constitutes a violent crime is not a fixed thing. The legislature's demonstrated that by changing things that are fixed penalties. That offender registration was a non-person misdemeanor. Now, as we know, and was argued Tuesday or Wednesday, we're now all the way up to then it became a non-person felony, and now it's a person felony. The legislature changed his mind on what
level 3 person felony.
Yeah, it's very different. So does that mean it's a different thing? It was the same exact act of not registering back when they came up with that. So that wasn't violent back in 96 or 95, whenever they did it. It's the exact same act. So what the legislature considers violent is not a fixed thing. And I don't see that this court can say, well, I think it's violent. But that's not the role of the court. This is a fixed rule and a good rule the court came up. Another example, identity theft in Williams. It didn't exist, but when it did exist, first it was a person felony, and then it became a non-person felony. So it became less violent.
But what your interpretation is that there's no ability to make a person's designation pre-1993.
No.
Or at least on an out-of-state crime pre-1993.
I specifically said earlier, I think there's a very good argument that murder, all these crimes, off-grid crimes of listed in 4706, and based on 4707 says these off-grid crimes are person felonies. And that there's a different rule because there is statutory authority. When you look at 4706 read in conjunction with 4707, that we would look at because it says, and amendments there too, in 4706. We don't, unless the legislature, because the legislature has demonstrated that at times it knows when you can use current offenses, and it didn't in this situation of out of states, that unless it is one of the delineated things, which are, and there's a number of them, Jessica's Law cases, murder, treason, weapons of mass destruction, terrorism. I've said, I think, and again, I don't want to sit and lay out the state's argument because this is something hypothetically that will undoubtedly will come up. But the bottom line is what constitutes a violent crime is in the eye of the beholder. Missouri has a statute, a crime called armed criminal action. It doesn't have a comparable. It's when you use a gun during crime. Clearly, that's a violent offense in my mind. But Kansas doesn't have a comparable statute, and under the Kansas statutes, I don't think there's any dispute that you have to treat that as a non-person felony. So the court doesn't just get to say, well, I think these are not. This is not a violent felony. This is a non-violent felony. You have to go based upon what the legislature has defined, and they did not define these. When it did not define them, which is in the case of robbery, then you have to use a non-person felony.
Counsel, I see you're out of time. Would you like about 30 seconds to wrap up?
Yes, if I could just wrap up, please. I just really want to be sure I covered everything. With respect to the state talking about we should look at the headings, again, I pointed out in my response to their motion that what the revisor said has never been held to be the law. It's only what the legislature actually says. So that sort of plan by the state fails. And again, as the court pointed out, the state's arguments with respect to 2147-24 were already looked at and rejected in Williams, and I agree, and I think that is correct. There was statutory authority in conversion cases to look at the crime as of July 1st, 1993. This lacks the same statutory authority. And in the absence of that authority, we would ask the court to deny the state's motion for modification.
Do we have any questions? Thank you, counsel.
The appellate defender is willing to say that 4707C2, which says except for off-grid felony crimes, which are classified as person felonies, will save murder. It will actually, if off-grid didn't exist pre-1993, everything's off-grid. So all off-grid crimes, or all pre-1993, can be considered as person felonies if we want to go that way. And that's another way for the statute to get, but that also seems to be questionably reasonable. I think that his argument about legislative intent actually helps us, and that it would be better to look at as the crime of the current conviction, what's the legislator's current view on what is a more serious crime, a person versus non-person. Incest has also changed. It's gone from being a diversion offense to being a very serious offense that is Jessica's Law. And it would be better to look at the 2008 version of incest rather than the 1992 when the legislators...
That has a due process feel to me. If you commit a crime 20 years ago and at that time it had certain consequences and severity, and then 20 years later you double or triple their sentence on the current crime, because they committed what they thought was not a serious crime earlier. Doesn't that have a due process feel to it?
It's no different than the sentencing grid as it currently exists in defining person and non-person.
Yeah, but that's what we're talking about, how we're classifying those prior crimes too. That's exactly what we're talking about.
To me, no. The due process, you're looking at the way you currently view crimes. I mean, if it was an indeterminate sentence, you would get to do the same thing. You would say, oh, incest is very serious now. You had a prior incest. We don't care. I mean, the fact that it was committed a long time ago is a reason possibly for a departure or something else. But no, to me, that does not automatically have any due process concern. Again, the state would just ask that you take this motion for modification under advisement and preferably go with the dissent wholeheartedly. Thank you.
Any more questions? Thank you, counsel. Thank both of you for your arguments this morning and this afternoon. Clerk will take this matter under advisement.